It now being 7 o'clock, and Ms. Van Giesen is expected, but we have a quorum. So I, as the chairman of the zoning Board of Appeals of the town of Orleans, call this regular meeting to order. Present with me are Messrs. Waugh and Taub, Mr. Cole, Mr. McCarthy, the board secretary, Amber Dauphiné. Also in attendance is the building commissioner of the town of Orleans, Tom Evers. Our agenda, which was duly posted, includes as its first item, well, we'll follow it in order, is an executive session with town council to review the status of litigation. That's the case of Feen versus Zoning Board of Appeals, which is pending in Barnstable Superior Court. Would you like to address this, please?
Can I ask a question?
Yes.
You use the words executive.
We have to, you have to vote to go into executive session. Somebody on the board has to make a motion. It has to be a roll call vote. And if the motion carries, then the chairman has to make a determination that the litigating position of the town might be prejudiced without the executive session. Upon that vote and that determination, then you can go into executive session.
Very well. Is there
Second.
a second?
Second.
Any discussion on the motion? All those in favor? Mr. Waugh? Aye. Mr. Taub?
Aye.
Mr. Cole?
Aye.
Mr. McCarthy?
Aye.
The chair, yes. The motion carries unanimously that the board proceed to executive session. As a matter of procedure, I determine that the executive session is necessary and appropriate to discuss a lawsuit named Feen versus Zoning Board of Appeals, and without the executive session, the position of the town might be prejudiced.
Right. So the meeting would be closed to anybody? I assume the building inspector would stay.
Thank you.
Everybody else has to
Sure.
go.
Or reopen. Okay.
They're coming back into executive session. I mean, open session.
Thank you, sir. Back out closer?
Thank you.
So, thank you, Mr. Chairman, for taking a few minutes tonight on this case. Can I assume that the board members are familiar with what this case was?
Yes.
Before my time, so I'm not.
Okay, well, it was a home occupation for woodworking, carpentry, home occupation. It was granted as a special permit, first in 2017. And a series of 6 conditions was placed on it, one of which was a condition that the special permit was good for 1 year and would be reviewed at the board's first meeting in December of 2018. The special permit became final. There was no appeal. And subsequently, towards the end of 2018, I'm not exactly sure who alerted who that it needed to come back before the Board of Appeals, but it appears to me that no formal application for a new special permit was filed. A request was made to get on the agenda. I think the building inspector facilitated in that with the board. It was not heard the first meeting in December, but it was heard in December. And after hearing, special permit issued again with the same conditions for 1 more year to be reviewed at the first meeting in December of 19, was condition number 6. An appeal was then taken of the decision by the petitioner in Barnstable Superior Court, challenging not the grant of the home occupation special permit, but the conditions. And the petitioner alleges to be aggrieved by a number of the conditions, but most importantly, the condition as to time, which is 1 year, and the condition as to no sign. I've read, let me step back. It was a very lengthy complaint. There was a lot more in it that needed to be to satisfy the statutory requirement to state a case, let's put it that way. A whole series of counts were brought. You guys were not only arbitrary and capricious, but did things unlawfully and outside your jurisdiction, and on and on and on and on.
That was the allegation.
Those were the allegations.
So someone,
I-
so someone said.
Right. I filed an answer.
Fake news.
Yeah. Yeah, everybody uses that now. Huh? So I filed an answer on behalf of the board, and I raised a series of affirmative defenses, including one which indicated that they really didn't have any authority to bring an appeal because there's a lot of law in the Commonwealth that if you're the benefit of a special permit and you're agreed by conditions and you don't appeal it and you exercise the rights and get the benefit of that permit, if you come back and ask for relief from those conditions, the board doesn't have to grant that relief. So I think they have some procedural problems. That said, they called me before town meeting, council did, and asked if the board would be willing to rehear the matter on those conditions regarding the one-year provision and the no sign. And I said I would try and get in front of the board as quick as I could, and when you were next available, and with town meeting and so forth. I think it's probably taken me 4 or 5 weeks to get here, but I'm here. In the interim, they got impatient and laid on me on the end of May, discovery in the form of interrogatories to every board member, requests for production of documents, you know, the usual discovery in a case.
Y'all are running up the bills sometimes.
Yeah, exactly. And then, of course, they called as soon as they sent that and said, oh, but that's just, as long as we can negotiate, we're okay, don't worry about the discovery. Bruce knows what I'm talking about.
How about
So-
deadlines, do they apply?
Oh, yeah, but, you know, zoning cases are a little bit different, because in a zoning case, no answer need be filed. So, I have a motion that I use in these, and will file it if this thing continues, to seek a stay of the discovery. It's a de novo proceeding. The court's directed under 4817 to hold a hearing. No answer need be filed. We've already filed a responsive pleading. I don't think that any of the depositions or the request for production of documents are going to lead to any discoverable evidence. The minutes of the board aren't even proper evidence in a zoning appeal. It's a de novo proceeding. So I think I could probably get relief from this discovery request, and if necessary, we'll do that. But that's time and money and so forth. And so I thought it would be good to come in and talk about the condition on time, because I was trying to figure out where the board was coming from on that. My examination of the minutes, my examination of the 2 decisions, and the findings of the board, finding that this was in keeping with the character of the neighborhood and so forth, I couldn't for the life of me figure out why there was this 1-year condition as to time. There's no question that in Chapter 48, Section 9, the board can impose in a special permit limitations on time and use. It's in the statute. However, I've researched the cases, and I find that conditions as to time have got to be directly related to some finding of the board as to why it needs to be sunsetted on a certain date or reviewed on a certain date. There's one fairly recent case where there was a 3-year provision. That's the shortest I've found. And the 3-year provision was on a radio tower, and the purpose in the 3-year provision was to ensure that the tower was still safe, because they had a specific bylaw finding the board had to make regarding safety and the construction of this tower and whether it withstood winds and storms and so forth. And so they had a periodic return to the board every 3 years for that. that was litigated by the tower company. Court upheld it because, one, the zoning bylaw required that the board make a safety finding and make a provision to monitor that, so there was a direct nexus to the bylaw. They made a finding on it in their decision. They papered it very nicely, and the court looked at those and said, there does appear to be some nexus in the record and the decision, and there clearly is a safety purpose, so it protects the public. So they upheld it. That's the shortest one I was able to find in terms of time. So my concern is that if this goes forward and gets to a de novo hearing, that condition, frankly, is, unless you guys can tell me that I'm missing something here, that there really is a nexus as to why this should have only been a one-year permit, that there was something that was going to happen, or whatever.
I can, I'll give you my spin on this. Both this hearing and the at the original hearing, the neighbors spoke in opposition, or at least in comment, to the granting of the special permit. Many times zoning boards, and I think this is certainly the case here, attach conditions to assuage and mollify, calm the objectors. Now, in context, and I grant that there was how to appropriately make this kind of finding, but the context was this, that the applicant had bootstrapped and originally established a use in that barn or large garage before ever coming in to and asking to be permitted. So we, at least some of us may have thought that to calm the neighbors and to convince ourselves that the interest of the town and the zoning bylaw would be served to test the credibility and reliability of the applicant to abide by the conditions. That was, at least, I think I could speak certainly for myself and maybe some of the other members. So we didn't make a finding to that was the reason for the one-year period, but we were looking for a period of grace to see whether Mr. Feen was trustworthy and whether he would do what we thought he could do. When we came to the final hearing, the last hearing, the applicant wanted to be, all the conditions to be dispensed with. And he was kind of adamant, for example, about the sign. So that kind of may have raised a flag with some of the board members that maybe he couldn't be trusted again to abide by the other conditions as well, because he didn't want any of them.
And Mr. Chairman, weren't there additional ones that were not
Yeah.
in the first time around?
No,
They were the same conditions.
There was
All
eventually,
of them?
yeah, after arguing, I mean, this wasn't, we eventually reached a consensus, the board did, but there was a good series of discussions
Okay, so you
amongst
have,
us.
okay.
And we
Yeah, yeah,
finally
abs-
came,
Not
There
as,
was some consensus on one issue. The sign issue, I was a minority vote.
okay,
In the last
Was it
meeting.
unanimous?
all right, all right. So that's my take on it.
Okay.
I'll
So in terms of the record, the first decision says one abutter appeared in opposition, and one letter was received in opposition. And then it goes on to say the applicant addressed the concerns. And then it makes all the positive findings, that this is, not more detrimental to the neighborhood, and, it meets the character of the neighborhood, and all the findings.
with respect to the,
If you, in the second time around, I don't know, was there anybody in opposition?
Oh, yes.
Oh, yeah.
More than the
yes.
first time.
Yeah.
More than the first time,
There were
okay?
multiple
The same,
neighbors who...
yeah, the same and more.
All consistently said that the terms of the agreement weren't being abided by.
Okay,
And so that really drove the conversation. And the biggest point that seemed to be a biggest issue, I don't think the time issue came up in great detail at the hearing. The biggest issue that took the greatest amount of time was the sign issue. And there was considerable amount of time being spent talking about how this wasn't a location where people would just happen by and wander in and check out goods, that this was only by appointment set up in advance with clients that there were contractual relationships with, and that it wouldn't be a big traffic issue. Well, my feeling, and I don't want to speak for anybody else at the time, is you have a street name, you have a street number, you have a driveway, and it's all well marked, and that's how people find you, and that a sign out on the side of the road or up at the building that would invite people to stop in when perhaps they're not set up for random stop-in would not be appropriate, and in that location would potentially cause traffic issues. So,
okay.
it was somewhat of a surprise to see the action taken after, there was no pushback or complaint during that entire initial one-year period.
Yeah, well, a couple things. The fact that a barn was built, that's not, I mean, I don't think he violated the bylaw building a barn before he came here.
No, he got the permit.
There's no prohibition in the barn.
He got the permit.
He got a permit, as far as I know, right? I mean,
construct.
check with the building commissioner.
There's
So-
nobody here that thinks that that barn was built for any purpose other than what he ended up getting.
Right, but I guess where I'm going with that, Matt, is that's not a violation of the bylaw. That if you want to use it for a home occupation, you go and build it. If you don't get the permit, shame on you, you got a big barn. But I don't think that that's, certainly if that's the testimony in the Superior Court, that's not going to get us anywhere.
I don't think that was anyone's issue here, that the fact that he needed a home occupation permit, which is what, after the fact, he came to us for.
Okay, so you think he was actually carrying out the home occupation for which he needed a special permit before he came, is what?
Yes.
Absolutely.
Right, right, okay. That's a little different, I was trying to follow that.
I think there was evidence to that effect. We, in the interest of retaining dignity in the proceedings, we didn't confront him that way, but there was evidence from some of the neighbors that that was the case.
Okay,
And I think that he was chided or scolded by the way that he set up the situation, and nevertheless, we allowed his hearing and to give him the relief that he was looking for.
okay. So, was it your intent to actually have the permit just be 1 year, or that there be a requirement that you kind of reviewed the conditions in a year?
Yeah, I thought it was, I would have, we reached consensus, I would not have, I would have attached all conditions except the year. In other words, because I thought that you needed that for finality, rather than, if there were to be an appeal, it would be for something that was complete, rather than looking at it a year later. Nothing really happened. The trouble is, nothing really happened during that year. So
Oh.
either he had the conditions or not. That was my thinking. But I acceded to the thoughts of my colleagues. That, and, there's a sense of the audience and the objectors too. That they weren't even happy with that 1 year period. But the idea was that we're going to review it, not that it would expire at the end of the year.
Well, see, that's the problem. The way it's written, it expires. And indeed, the way it was re-upped for another year was not proper. No special permit application was filed. If you go and look in the file, there's no application for a new special permit. It's just, I want to be on the agenda, and then another special permit issued. So the process here leaves a little bit to be desired. In fact,
So
will
what
probably
would-
found to not be appropriate.
So if we ever issue a special permit with a time limit associated, what is the correct procedure? A de novo filing with a new special permit? number?
Absolutely. When you issue a permit for 1 year, it expires. If you issue a permit and then say, within 12 months, the board will hold a public hearing to determine compliance with conditions, but the special permit is still going on, and if it finds that any of the petitions are in violation, the board may issue a show cause notice as to why the permit shouldn't be revoked. That way the applicant has got an opportunity, comes in, and if you decide to revoke it because you find specific violations, well, then he could appeal that. But the permit stays alive. So I don't think a court is going to support a board imposing a short period like that, 1 year, for the sole purpose of seeing whether somebody applies with conditions.
Well, that's okay. Well, will the court sever that one condition and allow those other conditions to remain in effect? Those were supported by evidence, too.
The others, I think, are pretty much standard. You tell me. I mean, I don't know how many of these home occupation permits, and the building commissioner can jump in here, that you issue, but some of these seem to be rooted right in the definition of a home occupation. There will be neither retail sales nor wholesale deliveries to the property. Isn't that part of, I think, the definition of a home occupation? I'll have to look at it in the bylaw again, but no full-time employees other than the applicant.
That's kind of.
Hop in here, yeah.
Later in that definition, it speaks to employees and kind of, it says, this definition does not include a home office which has no non-occupant employees on site sales or any other external evidence of the occupation.
It's a torturous
So they
definition.
mention employees in the reverse, saying that if you have a home office and you don't have any employees, then you're free, you don't need to go through this process. So that alone tells me that if somebody wants to have employees, they could have employees. I think that.
Provided the board found that the site was proper and,
Yeah,
you know,
exactly.
right.
But
And I have talked to people that have gotten home occupation special permits here who have, their business have done very well. They're small scale, but who have hired help.
Okay,
I think the very end of what,
And I don't think that's against the bylaw.
yep. Okay, thank you.
And no-
That's a good point.
No complaints were received.
Mr. Ford, I don't know if you have it, what Tom was talking about in front of you, but the following words or phrases of it are, does not include home office that has on-site sales or any other external evidence of the occupation. And I don't know if you had that to your ability, the tapes or the video of the hearings, but much of why the conditions and the timing went into this go to the phrase above in that section that says, may be approved by special permit, provided it is not injurious, noxious, or offensive to the neighborhood. And those go probably right to the core of what those videotapes of the testimony from the neighborhood would have evidenced,
Okay.
if that's helpful to you.
Yeah, it is. But of course, that's tempered by the board's finding. There will be no adverse impact, the proposed use will not be detrimental to the established and future character of the neighborhood and will be in harmony with the general intent and purpose of the zoning bylaw. These are your findings.
We had to make those findings, correct? Section,
If you felt that it wasn't, then maybe the permit shouldn't have been granted. I mean, that's what a judge is going to say. I mean,
we're trying to be
it either
helpful.
is or it isn't, So you have all these findings of adequate. There's another one here, the proposed use will have no adverse impact on the visual character of the neighborhood. I mean, you've got several findings here that, if I'm a judge, I'm going to say, well, you can tell me what the evidence was. Well, first of all, it's de novo, so the judge hears it brand new. Doesn't look at any videos, doesn't.
and I think we wanted to see, by having them come back, whether the things that the neighborhood testified to about outside, storage of
Right.
things and equipment,
Yes.
and not to mention noise in a summer time.
But you found that there was no problem with any of those, right?
Oh, if the conditions were complied with.
I never received a single complaint. from
In the whole
a
year?
neighbor In an area where I received complaints from neighbors often.
So why is another 1 year put on there if there were no complaints in the whole year? See, that's what a court is going to be saying to me.
There may not have been complaints prior. At the hearing, there were multiple neighbors from multiple sides of the property given a pretty consistent description of what they perceived to be going on there that was counter to what the conditions required.
Then
And
it-
so it was sort of their word against his.
Okay?
Um,
So was there machinery operation after 6? They testified there was?
Yeah, there was testimony.
And there would be no outside storage of materials or display, was there? Display of goods outside? Or did you hear testimony to that?
I don't remember
Not a
that.
display of goods, there was some storage of.
Storage? Okay, all right.
And anecdotally, I think the direct immediate abutter, that was one of the primary complainants, has put their property on the market for sale. I mean, it's anecdotal, but,
I hear you.
you know,
Yeah.
probably.
This is probably
There was
not-
there was other issues
This is
between.
probably not an appropriate comment. And we recorded an executive session as well, or the video operator noticed. I never understood the animus of the board. That's what I honestly felt, was the animus of the board picking up the vibration of the animus of the neighbors. And my prejudice was, this is so cool for Orleans, this is so nice, this is such an upgrade, and the sign should be there, and if he doesn't comply, somebody else has enforcement powers, not us. Our rules are what they are. Done. So that leaves me asking the question of Mr. Ford, if we wanted to follow a path of least resistance, given the complexity of the
Process.
strong feelings on each side, and the willingness of this gentleman to expend significant amounts of money, how can we most efficaciously move through this? Is there a way?
It sounds like if we completely turn tail on those two conditions, everybody's going to be happy.